But at the same time, you see that even in between the presentations, there is a certain differentiation of research and practice. Very obviously, LexisNexis is an enterprise offering practical solutions to the market. We are within the European project schemes doing research on stuff that later on for sure will be made or will have a lot of practical impact, but in a brief and a brief research project with limited funds, of course, we can't get to solutions that can easily be rolled out in the market. So this is one step towards a future solution that then will be of practical use. On the other hand, this situation where we are doing research gives you the opportunity to provide us with feedback on your requests, your needs, your requirements, what you would like to have, so that still we can take your feedback into account. We are in a relatively early phase. We have just started the project 1 year ago, so that we are very, very grateful for all the feedback we are receiving from your side, from the side of practice. Many-Laws is a project which actually tries to apply what might be called legal analytics, which in itself might be the application of big data analytics methods on legal data sets, on European legislation coming from different national jurisdictions and the European level jurisdiction, the jurisdiction of the EU itself. I don't want to go into detail of the theoretical foundations of the concept. Nonetheless, to justify why we are daring to use methods that have been developed for big data on comparably small data sets like those coming from the legal domain, to justify this basic approach, I think it needs to make some reference to the basics of what might be called legal analytics. Actually, legal analytics is nothing new. We have heard a lot of examples that there were ideas and concepts for many, many years. Have been ideas and concepts for many, many years, since the 1950s and 1960s. There has been discussion about how to make use of what might be called artificial intelligence. You know, this is a very unclear and unprecise term. Nonetheless, the basic idea is to have machines doing a job that so far has been done by human beings. Actually, for a long time in the 1960s, 70s, 80s, the focus was on what might be called rule-based systems. The idea was to model systems of rules, to allow the machines then to reason on individual instances coming under such a system of rules, individual cases coming under a system of rules. Nonetheless, it turned out that the effort for modeling these rule-based systems, and in particular the effort for adapting them on a regular basis to the changes in the rule sets, were too big to have a practical impact. So that was why there was this, might be called paradigm shift, some 20 years ago or so, when these so-called 3 V's allowed us to switch from what might be called rule-based systems to what might be called case-based systems, to machine learning, to natural language processing, to have machines running over texts, flat text, structured texts, deriving patterns from these texts, and allowing us to draw conclusions from these patterns. The main difference between the data environments we are acting in nowadays and the data environments of the 1960s or 70s, of course, on the one hand, are the volume of the data, Nowadays we have in domains like the commercial ones or the health domain, we have billions and trillions of data sets that we can use to train our algorithms. And at the same time, and necessarily associated with an increase in the volume of data, there needs also to be an increase in the velocity in which the processing is to be done. And this, of course, can only be done by parallel processing due to the limited capacity of the individual computers. So volume and velocity have led to this paradigm shift. The third V is variety. So now even in the legal domain, if we are focusing on just one domain, we will come to a point where the variety of data available will also be of relevance. When, for example, it comes, which goes beyond the limit of a project like ours, but when it comes to systems that would, for example, be suitable to build associations between actual real-life situations that users would refer to, and the legal concepts applicable on these real-life situations, then, of course, even the variety of data available coming from these different domains would be impacting the results of the research we are doing. I won't go into the technical details. I would just like to refer to one basic conceptual change that we have to be aware of. Traditionally, in the legal domain, in the domains of natural sciences, wherever we, since the 17th centuries or so, we have been used to thinking in dimensions of causality. Big data analytics isn't referring to causality, it's just referring to correlation. We are identifying correlations between patterns in the resources we have at hand. This is a stochastic approach which takes into account a certain margin of uncertainty. So we are arriving a certainty of maybe 80%, maybe 90%, maybe 95%. But normally we wouldn't arrive a certainty of 100%. This is something we have to take into account, and very well as examples from the commercial markets, for example in the US, which is, we are doing well in handling these margins of uncertainty. So the systems are of practical use. The systems that would be used out on the markets would provide the users, like law firms, like corporate law departments, like individual citizens, with a sufficient certainty to allow them acting on the ground of the information received with a certain chance for success. Having in mind that legal data, and this leads us to the next slide, normally would not really represent what traditionally might be called mass data. It's not, as mentioned, billions or trillions of data sets, it's thousands, perhaps hundreds of thousands of data sets, perhaps millions in some cases. I had a talk last week to a representative of one big German publisher who told me they have 30 million documents, whatever they call documents. Actually, they are breaking down what we would call documents, like court decisions, into files that then they would call documents. So they would, for example, separate a decision from the reasons given for the decision. So 30 million documents is quite a lot. It's quite a big set of data, but it's not comparable to the data sets available in the medical domain or in commercial domains, which leads us to the question, and that's why I'm mentioning these general background concepts here. This leads us to the question why we can dare to apply these big data algorithms on relatively small data sets like those coming from the legal domain. One main reason is that unlike the flat data coming from other domains like the commercial ones, legal data normally would be highly structured due to the tradition that we are facing in the legal world. court decisions, pieces of legislation, parliamentary business, would all follow structural patterns that have been developed over generations of actors. And so now the actors in the legal domain are so well used to these structures that they wouldn't like to do without them. That's something we have observed when we put the Austrian legislative process 20 years ago from a paper-based environment to an electronic environment. This would have been an opportunity to change the structures. But no way. The agents in the legislative system wanted to have us, the system being transformed to a new technology without changing the traditionally grown structures. They didn't even want us to change the layout. So this on the one hand blocks some development and prevents us from some progress, but on the other hand, we can be sure that over large periods of time, we can rely on the structural information we can retrieve from the documents that we have to process. But it goes even further. Beyond the structural information, the structural metadata that we can obtain from the resources, in many cases, in the legal domain, we also have semantic information, semantic metadata available. That's why I'm here referring to the Eurovoc. Perhaps you know, the Eurovoc is a big European legal thesaurus which has been developed by the European lawmaking institutions, Commission, Parliament, Council, and is updated on a regular basis by the European Publications Office. But it's not only applied by the European legislative institutions, but also by the national ones. Nearly every national parliament in the European Union would also apply the Eurovoc to its respective national legislation. Actually, in the different member states, the Eurovoc has been developed to different extents. So, for example, in the Czech Republic, they have done much more effort on adding non-descriptors to the Eurovoc. In Austria, we don't have made such effort. But anyway, we have this semantic annotation available, which would allow us to identify normative equivalences between national legislative documents or national legislative regulations in the member states. Which means that even though we have much smaller data sets than in other domains, in the legal domain we can rely on additional structural and semantic information that makes it easier for us to extract relevant knowledge from the documents in an automated, in a machine-based way. I won't go into detail. I would just like to share with you a very few examples showing you what's already going on even in Europe. There are examples from academia, from commercial businesses, and from the project landscape, so to say, that has been developed in Europe over the past decades. To refer to one academic study that has aroused a certain awareness even in the media. There was this study published in 2016, which from a very small data set, only 600 cases of the European Court of Human Rights, that were divided into two subsets. One subset for training the algorithms and another one for testing the algorithms, each of course around 300 data sets. From this extremely small set of data, the project was able to achieve what they called a prediction accuracy of 79% on the decision of the European Court of Human Rights with regard to 3 articles that have been chosen for this project of the European Convention of Human Rights. So prediction accuracy is not totally precise because, of course, they were working on cases that had already been decided on. But if you want to discuss the methodological implications of that project, we can do. This is just to show you that even from small data sets in the legal domain, you can achieve a relatively high quality of analytic results. Another proof of the quality of these results of legal analytics might be made by a simple reference to the success of services that are out there in the market. Not yet really to a high extent on the European market, but to a high extent already on the US market. And what they are doing, once again, is going back to relatively small segments within the legal domain. So they are not just going down or drilling down to individual classes of cases. They are even going down to the decision practice of individual courts or even individual judges. So one of the services which is provided by, or was provided by a startup called Rebel Law that later on was taken over by RELX, the mother of LexisNexis, like it mostly happens to successful startups. They would offer different suites of services that they called case analytics, court analytics, and judge analytics. So if you want to know how to argue in front or before a particular judge, then you can, for example, make use of this judge analytics service. They also add a service called firm analytics, where they are analyzing the performance of law firms. And there is even another service which is called premonition that would draw sort of a matrix that would take into account the relationship of classes of cases, courts, and law firms. So if you want to know what law firm is most successful in what class of cases before what particular court, then you can refer to this service. Finally, there are lots of European projects. So know that within the framework of European Union project funding, there has been developing a rich European project landscape, but still there are also national projects which play an important role, like the Italian Lex Certification project, which is about enriching existing legal resources from the Italian jurisdiction in a way allowing them to be better processed with legal analytics algorithms later on. And then there are the European Union funded projects like ours and the LINKS project, which is presented in another of these workshops today. Actually, if you compare these two projects, originally the idea was to have both projects together in one session here. But if you compare the approaches, they are very similar, because that's the standard nowadays in the field of legal analytics. So just to conclude my brief introductory remarks, to give you a visualization of the richness of services already provided on the legal analytics market, at least in the US. This is just the most important legal analytics services provided there. So you see, you have already broken them down to several subdomains of legal analytics services, and you see you have a wide variety of different services available, provided by the big players like the ones you know, and smaller players that would start up in the field with a good idea. So this is still a field where if you have a good idea, if you have a good concept of how to apply these new technologies on, for example, the legal domain, you can be successful in a brief period of time. A market analysis that was also published in 2018 was breaking down the market effect of these new services to two main dimensions, which this analysis called the volume cost and the scarcity cost of lawyer effort. So on the one hand, you see there is so many routine tasks that in the past have been performed by lawyers that simply by reducing the volume of these tasks, by transferring them to machines or to less qualified people interacting with the machines, you can make your services much more efficient. At the same time, legal expertise is also a very scarce resource. You don't have so many highly qualified lawyers, or you can't at least afford them. So that you really need to focus their qualified services on what it's really needed for, and leave the activities that the high legal expertise that your lawyers would bring in, leave the services where this expertise is not required to machines and less qualified people. So this is the situation which already is daily reality in the US. It's quickly sweeping over to Europe, and we are amidst this change. It's a fascinating time, so we can contribute a little bit to it, and I hope that events like this and discussions like the discussions on today's event will contribute to steering, to governing this quick development into a direction, making it useful to all the partners and agents in the legal domain. So I will now hand over.
So what is the Many Laws Project? Who are we? What do we do? Why do we do it? Let's start from three simple premises. The first is that the European legal system is multi-layered, it's complex. There are different public sector organizations producing legislation, legal documents, policy, storing them in their own databases, but these databases are siloed. Most of the time they do not communicate with each other, they're difficult to find, and that brings us to the second issue, that open legal data in the European Union is fragmented. Finally, the third major issue is that the law affects all of us. Whether you're a business person, whether you're a citizen, whether you're a public administrator, we are all bound in some way to the law. Some of us consume, some of us produce, some of us do both. So take all these three factors together and you've got many laws. The idea of many laws is to produce big open legal, to produce the proper environment for semantically annotated big open legal data. To do this, we plan to use high performance computing techniques and tools to provide services, to provide a set of pan-European services. We are funded by the European Commission under the CEF Telecom Public Open Data funding call. We are a 24-month. Our project runs for 24 months. We started last year in October 2018, and we are coordinated in Greece at the University of the Aegean. We now have a website. We've finished our conceptual analysis, and we are at the stage of developing the back end and building our services. Who are we? We are a 5-member consortium. We have 2 research partners, the University of the Aegean in Greece and the Danube University Krems in Austria. We are a private sector organization, Intrasoft International, headquartered in Luxembourg. We are also 2 pilot partners, the Austrian Parliament and the Hellenic Parliament, who are both legal data producers and will be our field test cases. We started work on looking at who uses legal data. To produce a credible legal information retrieval system that provides salient, appropriate, and legitimate information to its users, we had to look at who these people are, why they use information, how they look for information currently, and how they might do so in the future. We started with 5 basic actor groups. We refined these then to 6. We said there are citizens, there's a scientific community, there are legal professionals, there are business people, there are public servants, and there are third sector actors, all of whom require legal information to some degree or another. These categories can be divided into expert users and non-expert users, producers, exclusive producers of legal information, exclusive consumers, and prosumers of legal information. People from these user groups access and use legal information in both personal and professional contexts. However, we found that most people tend to do so on their own in professional capacities where they consider themselves experts in their professional domain. As private citizens, they tend to rely on other professionals. People, do they look online? Do they look offline? This was another question we asked. And we found that a large number of people did a bit of both. Search strategies are important because we need to know where people go to access legal information. It's surprising, but a lot of professionals still rely on offline sources. Lawyers still have large libraries. They still go to legal repositories. They go to public organizations with archives. So online isn't, just because we live in the information age doesn't mean online is it at the moment. People tend to look for authoritative sources of information. They want information to be trustworthy. And so again, offline and online sources come into play because where the repositories are held proves important. Günther will now take you through the conceptual model of the many laws architecture.
Start with a brief overview on the ground of a very, very rough diagram, but even this coming from the original submission phase of the proposal, so that it's in not all instances totally up to date anymore. But it gives you a good overview of the stages of data processing and data interaction. Of course, it starts with a phase of ingesting the raw data from the existing resources. Shefali already mentioned one main reason why we are mainly focusing on data coming from official sources, open government data. Another reason, of course, is that this is a main part of the European Union strategy in terms of making available and making accessible data. That was one of the reasons why the EU was so interested in having our project and having our project funded. For the EU Commission, it is a contribution to its policy of making better use of the existing open government data resources available throughout Europe. So, as Shefali mentioned, we are focusing on 2 national legislations in this project. In the long term, of course, the idea is to include all the national legislations in Europe, but in this early project we are focusing on 2 national legislations, the Austrian and Hellenic one, so that very obviously we are using the resources from the Austrian Open Government Data Portal and the Hellenic Open Government Data Portal, and then of course we are also using the data coming from the EU open data as, for example, representing all the huge data resources available in the EULEX database. Only in exceptional cases where the open government data portals are not sufficient to supply us with the data we need, we also would rely on proprietary data, which actually is the case for some aspects of the Hellenic legislative system. Not all the data necessary would be available in the Hellenic Open Government Data Portal, so that we are also making use of a private legal database, which is called Nomos, and luckily, which is operated by one of our partners, namely Intrasoft. But this is the exception. The rule is, and the basic intention is, to make use of existing open government data resources. Having ingested these data, by the way, to give you just a very rough idea of the technical or technological basis we are working on, we are mainly working on the CCAN architecture. You know, CCAN, the Comprehensive Knowledge Archive Network, is one quasi-standard architectural framework for interoperability of open data, allowing for many necessary functions to be performed through a lot of extensions that are coming with the CCAN architecture framework. So, for example, there is an extension which is called Harvester that allows us to harvest these data, and for most of the other functions we are performing, we are applying other of these extensions of CCAN. Once having the raw data ingested, the processing phase, still an offline phase. This is not yet a phase where we are interacting with users. This has to be done before it comes to actual interaction of users with the portal. In this processing phase, this is, so to say, the phase in which the artificial intelligence takes place. In this processing phase, we are running the algorithms over these huge, or at least large, corpuses of legal texts, and by iterative processing, by hundreds and thousands of iterative runs, we are identifying the patterns, allowing us to enrich the metadata that we have received from the open government data portals. Of course, the data there come with lots of metadata. For example, the Eurovoc annotations. But we need much more. This is on one hand why we are using several metadata schemas that we map together within our many laws metadata schema. We are using not only the DCAT AP, which is required by the European Data Portal, where at the end we will provide access to the many law services. DCAT AP, as you know, is a very general standard for data catalog software metadata, which is of course interoperable with other standards like Dublin Core, which is also interoperable with Eurovoc, but which is not specifically developed, or has not been specifically developed for the legal domain. But we are also using two metadata standards that have been specifically developed for the legal domain, and that's ELI and Accomantoso. ELI, probably you know, European Legislation Identifier, is the official standard promoted by the European Union institutions to identify legal and legislative information. And it also comes with a metadata schema. Much richer is the metadata schema of Accomantoso. Accomantoso, or as it is also called, LegalDocML, is a standard. It has actually been standardized by OASIS, the standardizing body, for legal and legislative documents. It's a descriptive standard which would allow for a very rich scope of metadata, much richer than the ELI one, in particular, for example, in terms of time management or life cycle management of legal data. When, as a user, you want to access legal data, of course, you want to precisely know whether a specific status of legislation not only was in force at a particular date, but also, for example, whether it was applicable on that particular date. And so we need this differentiation in the different, between the different classes of life cycle management, which is only be provided by the Accomantoso metadata standard. So we have these three metadata standards mapped into the many laws metadata set, and we can even enrich our metadata set by additional classes of metadata that we would identify as useful or necessary in the course of this processing phase, which, by the way, is also a function of one of these CCAN extensions, which allows us to also extend the metadata set that we are using. Here there is still a reference made to the ARIS Hellenic supercomputer cluster that originally we wanted to use. Actually, meanwhile, the University of the Aegean has acquired sufficient computing power of its own, so that probably the processing will be done there. And of course, it will also be done there in the future, because of course, this first processing phase, running the algorithms over the huge bunch of legacy legal data that we acquire from the resources, is an important elementary step to be taken first. But then, as a user, you need updated information, so we have to redo the processing on all the additions to the legal systems in question on a daily basis. And this then will, of course, also be done by the computing power of the University of the Aegean. So far we have been in the offline phase. Now coming to the online phase, the phase where the real interaction takes place between the users and the services that we are offering them. You see that very obviously we have to offer a service infrastructure allowing the users to formulate their searches. Actually, in the long run, even to contextualize them by, for example, referring to cases, I have to mention we won't take cases into account now. This is now foreseen for a follow-up project because we found out that we have enough challenges to meet with legal and legislative information. And then finally, we have to interlink, or the users will be able to find interlinked information within the environment of the European data portal, where different domains can be interlinked with each other. So within this very rough overview of the process steps and procedural steps we want to perform, I would now like to focus on one major value to be added to legal information within our project. What makes our project different from others? What kind of services we will offer that won't be offered by other services? And this is mainly the class of services related to what might be called the multilingualism issue on the European legal level. The European Union is, of course, maintaining multilingualism as a basic value, for good reason, to preserve the national languages as part of European cultural heritage, European identity. But of course, it also arises several issues, in particular for the legal domain. So very obviously, the European Union has to publish all its official legal documents in equally authentic national language versions in the official gazette, which leads to the inevitable issue of transformation between these languages. So if you have legislation mostly produced in English and or French as working languages, and then afterwards have this legislation transformed to other national languages, you have to come up with inequivalences. Taking this into account, the European Court of Justice has developed this questionable theory of comparing the language versions, the authentic language versions with each other to achieve an understanding of the intention or objective or telos of the legislator, of the European legislative institutions. We know this theory is questionable, but it is held up by the European Court of Justice, and that's why one task to be performed quite often is comparing the different language versions to get some, so to say, average value of interpretation. But not only at the EU level, but even more in the transposition of legislation from the European to the national levels, we have language issues. There is what I would like to call a development of convergence of legal terminology, which goes hand in hand with a divergence of legal language in the national jurisdictions. We are introducing more and more concepts and terms, even terms, from the European legal documents into the national jurisdictions, where they, in the beginning, are forming something like erratic blocks that would be different from the traditional legalese that we have got used to in the national jurisdictions. So convergence on one level leads to divergence on another level. Legal language and legal reasoning thus is becoming more and more complex, having in mind the multi-layered structure of European and national legislation. This leads us to certain questions that have regularly been worked on, and this I will show on the next slide. Certain questions that we would try to answer by certain services within the many laws environment. So this is a few of the services, of the language-related services that we want to offer. So, for example, we would like to offer a service allowing to compare the different language versions of EU legislation, to assess the national transposition of EU legislation from two perspectives. from the ex post perspective and from the ex ante perspective. From the ex post perspective, as a citizen, you might want to know or need to know whether a certain piece of EU legislation has already been transposed into your national legislation. From the legislator's point of view, you'd like to know what pieces of EU legislation you have to transpose. And you would also like to know, and this leads to the next level of comparison, to what extent or whether other European legislatures have already started or even completed their process of transposition. This is a question that has regularly been dealt with by the, for example, documentation departments of the European parliamentary administrations. They have even established an own network of knowledge exchange, which is called IPEX, but because everything is done manually, it's relatively inefficient, and actually it's quite difficult to get all the information that you would need to compare the actual state of transposition of EU legislation into national law. So that's one of the reasons why the two parliaments in the project consortium are so much interested in having these services available. Finally, as a citizen, as a business owner, whatever, you will very often come across situations in which you would like to know what legislation is enforced in other EU member states. If, for example, as a business owner, you want to extend the scope of your business delivery to another member state, you'd like to know what legislation would affect your business delivery there, so that the comparison of domain-specific legislation between different national jurisdictions within the European context would also be one of the main focuses. But as you very well know, whenever you are doing a comparison like this, you meet the linguistic issue. You meet the issue of multilingualism. And that's why automatic translation in the many laws approach plays such an important role. Automatic translation on both levels, on the search level and on the level of display of results. On the search level, we will have automatic translation of the search terms into other search terms of the same language, but of course into search terms of the respective target languages, which we are mainly doing by using the IATE services and added results of the pre-processing that we are doing. The results will be displayed in the form of what might be called working translations. So of course if we don't have the official translations for EU legislation, of course, but for the national legislations, we can just, for the pieces of national legislation, we can just offer what might be called working translation. We would never dare to claim any authenticity for them or particular quality for them, but they might be helpful to get a certain insight into the concepts of the respective legislation. Here we are mainly relying on the e-translation tool provided by the Connection Europe facility. For IATE as well as for the e-translation tool, we can state that the quality for all those domains covered by EU legislation is relatively high, because that's the text that these tools have been trained upon. The quality for those legal domains that so far are not yet covered by EU legislation is, of course, lower, significantly lower. Which means that in the course of the pre-processing that I've mentioned, we will have to undergo effort, even by manual intervention, to improve the quality, in particular for these legal domains not yet covered by EU legislation. But even at the end of this project and even after some manual intervention, we will have to face that the quality still will be unequal, that the quality of automatic translation for texts coming from these other domains, from these other legal domains which are not regularly covered by EU legislation, will be significantly less than the quality for the domains covered by EU legislation. It's work in progress, it's research. We will, of course, be able to give some feedback to the EU tools, to the e-translation tool, to the IATE, of course. We will have some plugins. There was, for example, the plugin produced for the Austrian EU presidency that on the one hand, took into account specific Austrian legal language, which, as you may know, is significantly different from German legal language. There is the study by Rudolf Mohr, who identified around 2,000 different concepts in German and Austrian legal language. And this is only a selective. This is only a selective study, which would not claim totally covering these differentiations. Anyway, we have this plugin which takes these differences into account to some extent, and which also would cover some of the domains not covered by EU legislation. So we try to integrate the available resources. We try to add quality to them by some intervention in the course of the pre-processing phase. Nonetheless, of course, it's research, it's work in progress, and so they will have a lot to be done in the future. This is one step on the way. But do we have enough time for the mock-ups? Probably not.
Time again, but if you have any questions, we've got time for one or two.